You know that feeling, right?
Yeah.
Something breaks in your place, maybe a leak starts, and you just know getting it fixed is going to be a whole thing.
Oh, definitely. That sinking feeling.
Yeah, and you reach out to the landlord, maybe hopefully, and just get crickets. You're stuck with a leak and the stress. Does that sound familiar to you listening?
It's unfortunately, yeah, a pretty common story for renters. And today we're diving into a case where that exact frustration really boiled over.
Exactly. We've got this situation, a renter with a serious water leak. Bathroom.
Yeah.
It's not just a drip.
No.
It's spreading. Damaging walls, getting into the living room, the bedroom. I mean, really messing up the whole living space. They've called, they've messaged the landlord again and again, and just nothing's happened.
Which right away brings up that big question, who's actually supposed to keep the place, livable?
Right. But here's the twist. Instead of fixing it, the landlord turns around and says, "You're out," threatens to end the lease early.
Wow.
Yeah, it gives the tenant 30 days to move or face legal action for.
Yeah. Unlawful occupation.
Yeah, and then just cuts off communication, blocks them.
That's a really tough spot. Puts the tenant in a horrible position, questioning their rights, the landlord's duties, everything.
Totally. So that's our mission for this deep dive. We're going to unpack this using a legal guide on rental disputes as our source here to figure out the rights and options available. This is really for you, listening, to help understand how to navigate something this messy. Okay, so first things first. Repairs. What's the landlord's actual responsibility here?
Well, generally, the law kind of assumes the landlord will keep the property in decent shape, habitable.
Right, habitable.
Yeah, our source confirms that repairs, usually the landlord's job. The idea is you're paying rent for a place that actually functions, that's safe.
But are there times when it flips? When the tenant has to pay for repairs?
Yeah, there are exceptions. Like if the lease specifically says the tenant handles certain things, okay, that's one thing. Or, and this is key, if the tenant caused the damage, negligence, misuse, something like that.
Okay.
But a big bathroom leak spreading everywhere, that sounds more like a problem with the building itself. Plumbing, maybe just old pipes, wear and
Mhm.
tear. And that stuff, that usually falls squarely on the landlord.
So yeah, a leak this bad is almost certainly the landlord's problem to fix. What about the tenant, though? Do they just sit back?
Well, the source does mention tenants need to let the landlord in to do the repairs. You can't block them from fixing things.
Sure.
But that's not the issue here, is it? The problem is the landlord isn't doing anything, even though they know about it.
Exactly. It's the not doing anything. So if the landlord is dropping the ball on repairs, can the tenant just leave? Break the lease?
Our source suggests, yeah, pretty clearly actually, that if the landlord fails significantly to make necessary repairs that really affect whether you can live there comfortably, that can be a valid legal reason for the tenant to end the lease early.
Ah,
Think about it like, well, if one side isn't holding up their end of the bargain, providing a decent place, why should the other side be stuck?
that's a really important right for tenants. Is there a specific way they have to do it, like a process?
Yes. Usually you can't just walk away. The tenant generally needs to give the landlord a written notice. Tell them, I'm terminating the lease because you haven't fixed XYZ.
In writing.
Right. And the source mentions it's typically a 30-day notice. It sort of gives the landlord one last official chance to fix the problem before the tenant legally ends things.
Okay, 30 days notice. Got it.
Yeah.
So the tenant might have a way out. Let's go back to the landlord's threat, though. Ending the lease early, that whole Tay thing. Can a landlord just do that?
Well, this is where lease agreements being contracts really matters. Landlords can't just tear them up whenever they feel like it.
Right.
Our source is clear. There have to be specific, legally allowed reasons for a landlord to terminate early.
And what kind of reasons are we talking about, according to this guide?
It lists a few things. Often needs 30 days notice from a landlord, too. Things like being way behind on rent, like 2 months plus. Making big changes to the place without permission.
Unauthorized renovations.
Exactly. Or subletting when you're not allowed to. Or maybe intentionally damaging the place and not fixing it or paying for it. There are also some reasons that might not even need notice, like using the property for illegal stuff or renovations that actually damage the building's structure.
Okay, but none of that sounds like what's happening here. The tenant hasn't paid rent,
No,
changed the structure.
no,
They're the ones asking for repairs because the property is damaged.
precisely. So if none of those legal reasons apply, the landlord's attempt to terminate early It likely has no legal ground.
Meaning the lease is still valid.
Exactly. The lease agreement is still in effect. So the tenant being there, it's based on that valid contract. It's not unlawful occupation.
Which blows that whole accusation out of the water, doesn't it? So the tenant isn't actually, like, trespassing by staying put while this is unresolved.
Right. The source helps here. It talks about unjustified entry being an offense. Keyword. Unjustified. A tenant staying in their rented home while trying to sort out a legitimate problem like waiting for major repairs they requested? That doesn't really sound unjustified. They entered legally under the lease, and they're still there because of issues tied to that lease.
So it really sounds like the landlord's just using a scary legal term to, well, scare the tenant.
It certainly looks that way. The source even points out a case where a landlord got into trouble for entering without permission after a lease ended. So landlords have rules too.
Good point.
Yeah, so the landlord can't just slap a criminal label on the tenant for not moving out on their arbitrary deadline, especially when there are serious unfixed problems they're responsible for.
Okay, so the tenant probably has the right to stay, legally speaking, but the landlord's gone silent, blocked them. How does the tenant even communicate now? How do they make their case?
With the communication cutoff, yeah, formal documentation becomes absolutely vital. The source strongly recommends using
The registered mail thing?
exactly registered mail with proof of delivery. It creates a legal paper trail. Proof it was sent, proof it was received. Can't argue with that.
Makes sense. A formal, trackable message. What should be in that letter?
It needs to lay everything out clearly. First, state the water leak problem again. Describe the damage. Stress the urgency of repairs for habitability. Second, point out it's the landlord's job to fix it under the lease and give them a deadline, a reasonable deadline to act.
Okay, state the problem, landlord's duty, deadline. What else?
Third, definitely address the landlord's termination notice. Say, I don't accept this, you don't have legal grounds, and maybe mention their failure to maintain the property as the real issue. And fourth, if the tenant is thinking of leaving because of the lack of repairs, the letter should say that too. Mention their right to terminate with 30 days notice and state they're willing to do a proper handover that here when the time comes.
Right, the joint inspection. Why is that handover process so important again?
Well, the miss is when both landlord and tenant check the place together at the end. Agree on the condition. Our source stresses that if you don't do this joint inspection, or at least formally notify them you're ready for it, just, dropping the keys and leaving might not count legally as returning the property.
So just moving out isn't quite enough. Could backfire.
It could, yeah. Without that formal foo, you might get into arguments later about damage or have trouble getting your security deposit back. It just wraps things up cleanly for everyone. For the landlord, it means they officially have the property back. For the tenant, it means your responsibilities are done.
This is, wow, really practical stuff for anyone stuck in this kind of mess. So let's boil it down. What are the immediate, actionable things someone listening should do if they're in this situation?
Okay, based on the source, few key steps. 1, send that formal registered letter, the FOOCH, lay out the problems, the landlord's duties, your position on their termination attempt. Crucial.
Right, the letter.
2, seriously, think about whether you want to terminate the lease. If the repairs aren't happening and it's bad, maybe giving your 30-day written notice is the way to go. Follow the legal steps. And 3, and this is really important, get outside help.
Outside help. Like who?
The source mentions the 1950 Consumer Service Hotline that's run by the Executive Yuan Consumer Protection Committee. Or you can contact your local government's land administration office or their consumer protection officers.
Official channels. What can they actually do?
They're set up to help mediate these kinds of disputes. They can explain your rights, maybe put some pressure on the landlord to respond or act reasonably. The source notes there was some legal discussion about whether landlords count as business operators for consumer law, but the general takeaway seems to be, yes, residential leases are covered, tenants should seek help. So contacting them is a really solid move.
Okay, summarizing those actions again for you listening. Document everything. Send the registered letter demanding action and stating your case. Decide if you need to give formal notice to leave because of the repair issues. And definitely call that consumer hotline or local government office for guidance and backup. Any final advice from the guide?
Yeah, just reiterating, keep all records. Screenshots, photos, notes of calls, copies of letters, especially that teach. It's your evidence. And, think carefully about your legal options. If it gets really complex, getting advice from an actual lawyer might be necessary. Remember, everything we've talked about is based on the principles in this legal guide we looked at.
So for you, the listener, if you're facing this kind of landlord nightmare, know your rights. Understand the landlord has to provide a livable place. Don't let bogus threats intimidate you. And remember, formal communication and reaching out for official help, those are powerful tools. Use them.
Absolutely. Knowledge and clear, documented communication are really your best allies here.
Right. And that makes me wonder, thinking about the power dynamic that often exists between tenants and landlords, what other protections do you think are really essential for tenants everywhere to know about? And maybe more importantly, how can we make sure those rights are actually enforced effectively? Something to chew on after today's deep dive. Thanks for tuning in.